Hi, it's Anne-Marie from Charmed Life Therapy. So as promised when I did a video earlier this morning about Leslie, about Wayfarer getting back to Wesley Sloan. Oh dear, I think I need another cup of coffee. Wesley Sloan, we might have to rename her Wesley Sloan. So Wayfarer got back to Wesley Sloan this morning. I think at this point we should just confuse everybody's name and just mix them all up together. Yeah, so I made a video earlier about Wayfarer clapping back at Leslie Sloan and her sir reply, her excess information, if you like, in terms of James Vituska and the one random text message that presumably Wayfarer's whole case rested on, according to Leslie Sloan. So I covered that in a brief video earlier, but I wanted to give due attention to J. Alexander Townsend's recent filings on the docket. You've got to laugh at this point for poor Judge Lyman. And probably the guy in Nevada too. It's like, is this docket in my control at all? Is this court case anything to do with me anymore? How did I get involved in this? How did my name come out of the hat? They must be they must feel like they're in the twilight zone. Because I imagine this is quite unusual, but J. Alexander Townsend, man or woman, I'm not sure, my little head goes man, but it isn't necessarily. It sounds a masculine name. I guess that's the gut feeling, but the voice of the people, I guess you could call it. So yeah, we're going to run through these and see what we can make of them. So let me just start by sharing my screen. And I'll try not to bring Wesley Sloan back into it if I can, although maybe part of these documents. Right, let's have a look. Let me just try again because that didn't look like it worked. So I'm just going to try again. Share screen. There we go. That looks more like it. So this is, that's 703 on the docket. Right. So this is the main crux of it. So, J. Alexander Townsend presenting an omnibus of motions to quash and for non-party relief as a collective and as independent members of an identifiable group with a shared interest and protectable rights. And I guess J. Alexander Townsend, I guess some of you out there know who it is, but it could also be a group of people who are collectively doing this under one banner name, I guess. But I believe J. Alexander Townsend, is he, they, she are subject to a subpoena as well now, I believe. So I haven't run through these documents. I'm just literally mostly going to be doing it with you here. I had a quick flick through it, but I haven't studied it by any means. So if you have any criticisms, what you have to remember is that you're here just to basically hear me riffing and for what nonsense comes off the top of my head that may or may not appeal to you. I don't pretend to do this properly, accurately, or be the most insightful. This is my perspective, my feeling about it. So may it please the court. For the reasons discussed herein and in the accompanying memorandum of law, the non-party J. Alexander Townsend respectfully requests that the court grant the non-party's motions for relief in this matter. Such motions include a motion to quash, as well as a special motion for sanctions for abuse of process and contempt of court. So notice of omnibus motion. Non-party Townsend seeks from this court the following measures of relief. Declaratory judgment pursuant to FRCP Rule 57 that for the purposes of this action there exists a collective group of individuals who possess the shared interest of belief in that they are outspoken skeptics of Ms. Lively's allegations against Justin Baldoni and the Wayfarer parties. They collectively and individually associate freely for this purpose in online forums and in live chat settings. Ms. Lively herself has identified them enough to seek legal demand from them. As well, Ms. Lively's allies in the media have identified them enough to disparage and condescend to them. As members of the collective, we have rights of free association and free speech that are protectable. As an identifiable group, I and we seek a declaration ascribing joint rights to the group as a whole. insofar as they are derivative of the members' individual rights under the Constitution of the United States of America, the Canadian Charter, well, should that read of Rights and Freedoms, and the English Bill of Rights of 1689. Let me just see, I'll just blow that up a little bit for you, that might help. So, 2, a further declaratory judgment pursuant to FRCP Rule 57 that there exists a subgroup of the collective in Section 1 above that have additional considerations regarding their rights to anonymous speech. The one additional factor that distinguishes this subgroup from its parent group is that these members engage with the members of the parent group without revealing their true online identities. This group itself is another identifiable group, and the whole should have joint rights in addition to the individual rights they already possess, and a declaration to that effect is sought as well. This will have special relevance to the additional relief sought below. I move to quash the Google/X subpoenas pursuant to FRCP Rule 45D3A and FRCP Rule 45D3A. So that's 3 and 4. In their entirety, as the subpoenas seek privileged information and are unduly burdensome. As well, the subpoenas fail significant legal tests required where the compulsion of anonymous speakers in court risks unmasking the individual. This is particularly salient where it concerns Ms. Lively's inability to make out a prima facie case for retaliation, as both a member of the collective and an individual whose information, communications, and identification are subject to subpoena. And J. Alexander Townsend has previously eloquently presented a case about Ms. Lively not having an ability to make out a prima facie case for retaliation. I move to modify any of several subpoenas as the Lively parties have commissioned pursuant to that particular rule and that particular rule, as to the effect that the subpoenas seek privileged information such as source communications for journalistic purposes, and that they are unduly burdensome to anonymous people who may have incidentally communicated something to a known individual. As well, the subpoenas fail significant legal tests required as to the application of the subpoena to anonymous communications where the compulsion of anonymous speakers in court risks unmasking the individual. Once again, this is particularly salient where it concerns Ms. Lively's inability to make out a case for retaliation, brought as both a member of the collective and an individual whose information, communications, and identification are subject to subpoena. So, motion for a protective order pursuant to FRCP 26C, seeking to prevent the use and further acquisition of evidence obtained through abusive and oppressive tactics for the claims of retaliation put forth by the plaintiff. Plaintiff has admitted she lacks any independent facts to form a reasonable basis to sustain the claims. I'm guessing that's to do with deposition extracts and various other things that have come out, because she's basically said, hasn't she, more than one of those extracts, that she's not aware of information other than has been fed to her by counsel, basically. That's what she's admitted in deposition anyway, that she's not aware of specific articles authored by the likes of Jed Wallace. It's more the groundswell of opinion that she wants to ascribe to a certain party. Motion to take judicial notice that the motion at docket number 660 to preliminary challenge the basis for certain subpoenas has gone unopposed, in that it is a letter motion, and the court's explicit direction under its individual practices number 1C paragraph 3 is that letter motions must be responded to within 2 business days. That time has elapsed absent any response. There's so much on this document on this docket that is going unanswered that's backing up. Motion for sanctions against plaintiff's attorney for abuse of process pursuant to the court's inherent powers as articulated in cases such as Chambers v. Nasco, Inc., being that meritless claims were brought for improper and oppressive purposes in this case. Number 8, motion for sanctions against plaintiff's attorney for contempt of court by authority of 18 U.S.C. section 4012. 9, motions for fees and costs. And then, just to wrap it up, It's funny because I read that and it's like giving a kiss to the judge on the end of that signature. That's where my mind goes to. The supporting case law and argument regarding these motions are described in the accompanying memorandum of law. So there's one of the exhibits that are mentioned. There's only one so far that is available to me on the docket. This exhibit C, a couple of them are not just freely available just yet. So I might be jumping the gun here, but this is the one that was available to me this morning when I was looking at this. So let's go to this, shall we, first? We'll do this bit first. So this is the memorandum of law in support of the omnibus motions for relief. It's kind of using her own language against her, isn't it, as such? This is a second omnibus the second mention of omnibus we've had. So summary of court argument. Your Honour, basically it comes down to this. I've been watching this case closely and I have observed an abundance of irregularities that have led me to certain beliefs about this case. I am open to challenge to rebut these presumptions. However, I believe there is a scheme running through this case like a vein of sulphur through a volcano. This case, in my opinion, originally involved a troubled young woman with certain narcissistic tendencies who developed a delusion, a persecution complex, which has clouded her mind. So I don't necessarily, if this is the vein, I don't necessarily totally agree with it, but I get kind of where it's coming from. It's kind of, there's so many aspects to it, to my mind, and I'm not sure we will ever fathom all of it. I believe that that is an aspect of it. But then I also think there's an aspect of that it was, a lot of it was calculated and a plan, and that even if it wasn't originally supposed to be about taking over the movie, it quickly became a plan about taking over the movie. And the delusion is so wide-ranging as well, because you've got, did she truly believe that she'd been SH? Did she truly choose to interpret that like she chose to interpret that it weight shamed her? Or is that part of the campaign to take over the movie and to discredit Justin? You've also got the aspect of her trying to make out that he was this malignant male stalking about the set that was purely being a method actor and being impossible to deal with and all of that, that she had to run to Sony and say, I have to do this and I have to do that because he's not doing any of it. He's being lazy. He's just stalking around this set, putting the male gaze on it, basically. There's so many aspects to it that it's hard to just say this is a troubled young woman. It's difficult, isn't it? I get where they're coming from, though, and I think it's going to be a really interesting take on it. So let's continue. So 2, this woman actually does believe that people failing to see her artistic and creative potential enough to prevent her from inserting herself into their own creative works is wrong. She feels bad enough when this happens that she thinks it is akin to how victims of SH must feel. She further believes that it is wrong that society has not provided means of legal recourse for having her creativity squelched. Ergo, she has chosen to falsely allege SH in retaliation, justifying it with her feelings of failed recognition. Okay, so it's really interesting, isn't it? So 3, again, despite being functioning, she is troubled. And the problem is as well, she's heavily backed, isn't she, both by money and by yes people behind her. And a husband who has a particular perspective on life as well. But she has money, and that's where the scheme comes in. She found lawyers instead of being on their client's side and helping her to come to the appropriate conclusion that she already got everything she wanted and her claims are not actionable. These, what in my humble opinion appear to be unscrupulous lawyers, chose to use her delusion to keep the spigot of money running, racking up the billable hours while assuring the client not to worry because they will get the fees shifted and make the defendant pay her back in triplicate. As part of this, yeah, that's the problem, isn't it? And another problem that she'll have is that she's racking up all of the billable hours, and even should she win, she will have to prove that all of it was necessary in order to win her case. But right now, these attorneys are probably saying, so are you going to get this back in triplicate? It doesn't matter what it costs. So far, as part of this scheme to keep the money coming in, I believe they have chosen to engineer the situation to indulge their client's unreasoned beliefs and fuel her desire for vengeance. They were well aware that their client would perceive any backlash as unjustified persecution, so her lawyers have gone out of their way to make outrageous legal maneuvers targeting outspoken people with oppressive legal gambits. They also allow her to go out and carry out her own optically damaging behaviours. When the inevitable wave of backlash crashes in, they turn to their client and say, look, they're at it again. They're all against you. Give us the go-ahead to make them pay. And Ms. Lively obliges by opening the money spigot even further. I mean, I did feel at the time when those Google subpoenas first landed and all that confusion that went on there, I think I said in other videos, I'm sure I said, that part of that confusion and people not knowing what to say in response to people phoning that reception desk and stuff like that was that I'm not sure that they didn't expect an immediate pushback from Google like Meta had and Pinterest had. So they were on the back foot, Lively's camp, because they didn't realize it was going to move that fast and people would be aware of it that fast. I think they thought they'd have some time to figure out how they were going to swing it, and they didn't. It went live before they were ready. But they should have done a little bit of research about that, shouldn't they, basically? So 5, why does this matter in regards to this motion? Because in executing this scheme of indulgence for financial gain, these lawyers have engaged in reprobatic actions. I don't know if that's the I know like reprobate. I don't think I've ever come across it in that way. Reprobatic actions, throwing 100 or so non-parties, and indeed this court itself, under the bus. They've targeted us with oppressive and pointless subpoenas, forcing some of us to pay thousands of dollars and others of us to waste hundreds of hours researching case law through painful, gut-wrenching, sleepless nights of worry. 6, they've also unleashed a gargantuan mountain of frivolous, duplicative, oppressive, and sometimes just plain goofy legal filings and motions, multiple volleys of expensive motions for sanctions, motions to compel that were plainly unnecessary, motions to change venue when venue did not matter. Yeah, Ms. Lively's lawyers have lied to the defendants, the court, and even their client, the plaintiffs, the Exhibit B. I might have to either come back to this because it's Exhibit B we don't have. I might just pause it and come back and have a quick break and see if anything's gone live on the docket. So I know that this omnibus will make things worse for Blake and add some clutter to this mess temporarily, but I and we are not her lawyer, and the court should recognise that we are people too and we have rights. Some of us are women who are even less advantaged than Blake Lively is. Some even look as aesthetically pleasing as Blake Lively does. Just because the plaintiff may remind us all of Princess Peach does not suddenly mean that her air of royal authority has a place in this justice system. She really did come across in those excerpts of the deposition. Sorry, I'm saying I'm being naughty there. Excerpts, because I got smacked on the hand on the comments yesterday for saying extracts and not excerpts. So apparently I was talking about excerpts of the deposition yesterday that had been released. I got told to proofread stuff, but I'm not moaning. I did explain to the person that I'm not here as a journalist, because she was saying if I'm a journalist, then I'm supposed to proofread. I don't have time to proofread. I'm just going with it. If you don't like it, just go to somebody else. Don't beat me up. But I think in those deposition extracts, it did come across that she's removed. She's removed from what's going on now. Whether that's something they coached her to do, there could be an element of that. But without seeing her face and her body language and her tone of voice and the rest of it, there did come across an element of confusion about it all. And but that's what I've been told. You know, I've been told that Jed Wallace acts in a clandestine manner. Everybody says so. And it's like, everybody says so. Who is everybody? Who is everyone? You know, who are feeding you information? Who's messing with your head, basically, isn't it? So it does make you start to think of this princess who, you know, people are having fun with. It's like many will accuse our English royal family of, it's all the people behind the scenes that are manipulating things, you know what I mean, that have the real authority. And you get the sense that this may be happening here too, that there's so many elements at play that Blake Lively, as nefarious as she may or may not be, is not the worst that's going on, really, isn't it? So arguments regarding motions 1 and 2 for declaratory judgment. 9, the court has broad discretion under 28 US Code. I guess that's section 2201 or paragraph 20201. I'm not sure what that symbol is supposed to represent. There, don't shoot me. To declare the rights and other legal relations of any interested parties by way of a declaratory judgment. I seek such declarations as it pertains to this case. I request of the court that the individual right of free speech and right of free association and assembly as described in the First Amendment of the Constitution of the United States of America be conferred on these people as a group, some of whom Ms. Lively and her counsel have targeted with subpoenas, namely that group of people who have professed a skepticism of Ms. Lively's claims and her tactics, suspecting her and her attorneys of manipulation for ulterior motives. As a subset of this large swathe of people, those who act anonymously to speak on the issues of this case are worthy of collective protection as well. As such, we request further a judgment to that effect as well. Just blow that up a bit. So 10, there is precedent, a sound legal basis for this approach. The NAACP won a landmark Supreme Court case in 1958 in this regard. A legal framework for group rights was created to protect the rights of a number of people, where the whole group was collectively being unfairly targeted based on their shared interest in a common set of beliefs. Below is a quotation from the case cited as NAACP versus Alabama, blah, 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 which reads, action which, although not directly suppressing association, nevertheless carries this consequence, can be justified only upon some overriding valid interest. Effective advocacy of both public and private points of view, particularly controversial ones, is undeniably enhanced by, and obviously this is highlighted here, enhanced by group association, as this court has more than once recognised by remarking upon the close nexus between the freedoms of speech and assembly, and got case law quoted there. So it is beyond debate that freedom to engage in association for the advancement of beliefs and ideas is an inseparable aspect of the liberty assured by the Due Process Clause of the 14th Amendment, which embraces freedom of speech, and more case law quoted there. Of course, and highlighted here in bold, it is immaterial whether the beliefs sought to be advanced by association pertain to political, economic, religious, or cultural matters, and state action which may have the effect of curtailing the freedom to associate is subject to the closest scrutiny. So 12, my intended purpose of seeking these declaratory judgments is for there to be a legal means to redress grievances in this court for the collective as a whole, even where individual members have not yet been or no longer are individually under legal compulsion. So it's arguing the point, isn't it, basically, that people have a shared interest here, including like the anonymous people and the people that kind of haven't even attempted to try and address the subpoenas that have been landed on them because they don't even know where to start. It's so overwhelming. So in those instances, they're presenting an argument basically here that there should be the option for the collective to act as a whole because they've got shared interests, and people have varying abilities to respond as well. So it's in the interest of fairness, isn't it? And justice. Right, so the members continue to bear the negative effects of the chilling of their rights and the advancement of the dialogue they once enjoyed, even if they personally aren't named at this time. And I do think people have had to be a little bit careful, those that have received subpoenas. They're a bit more on the guard about what they feel like they're free to say. I think you can see that already. Joinder of rights would facilitate members of the collective who had previously been subpoenaed to request relief from the court despite being individually dropped from the request. That the alleged ongoing harm to the collective as a whole justifies our right to seek sanctions or compensation or fees, protective orders, and non-exhaustive sundry. We did not arrive as a group, but Ms. Lively opened our eyes to the existence of our common beliefs, and we will fight to express them, free from vindictive and inappropriate oppression. Further evidence of the existence of an association in this regard can be found in Exhibit A. And that's it, isn't it? As we were saying yesterday, when you have Andy from Popcorn Planet interviewing Perez Hilton, the one thing you can say about this case is that it has brought people together. And it's a shame that we have to be brought together by a situation where we have to come together to fight against one person's perspective of something, basically, and you know that people have to suffer in all of this in order to bring us together. That we have to have the likes of this happen in order to do that. That we can't find better ways to do it. But at least it has done it. It's opened up dialogues, hasn't it, about many interesting things. So Section A, Ms. Lively cannot make a prima facie case for retaliation. Part 1, the plaintiff herself lacks any facts in support of the claim. So Part 1, in her hours-long deposition, the plaintiff admitted she personally had no reasonable basis in fact to sustain a claim of retaliation. Such admissions took place in at least 2 exchanges that we know of. First, in docket number 5961, we find an unsealed excerpt from Ms. Lively being deposed by Brian Friedman. On page 202, page 4 of the excerpt, lines 20 to 23, we find the following exchange. Attorney Friedman, what about the defendants? What did they do that's part of the ongoing smear campaign? And Lively answers, like I said, outside of conversations with my attorney, I'm unable to answer that. 2. Furthermore, in docket 649.3, we find another unsealed excerpt from Ms. Lively's deposition in which she is being deposed by Charles Babcock. On page 251, page 14 of the excerpt, lines 16 to 25, we find the following exchange. Babcock, is there anything you've seen in writing that you believe that Mr. Wallace has authored that is defamatory, disparaging, or says mean things about you? Lively, that's happening currently? Babcock, well, let's start with currently. Sure. Lively, currently, I don't read news about me or go on social media about me. So personally, I don't have knowledge. No. And as other people have pointed out there, possibly she is not looking on social media right now, that people have advised her not to. But on the other hand, many people think, could you possibly imagine a world where she's not actually devouring every inch of social media about her? So that's what makes this case so fascinating. It's so divisive, and that there's so much you'd love to know about it that we will never know, you know. And lastly, IDEM, page 252, page 15 of excerpt from lines 1 to 22, Mr. Babcock finishes this line of questioning. That might be item, or it might be some legal term, I don't know. I don't pretend to be the best educated about all of this. Attorney Babcock, and going backward in time, can you identify any written thing that you believe Mr. Wallace published about you that is defamatory, disparaging, in any way offending to you? Lively, a specific article, or no, I don't know a specific article. Babcock, okay. And it could be a post, anything in writing that you can look at it, like I'm looking at this screen and reading, and you're not aware of anything that he's authored, that you can actually see whether it's a post, an article, or a video, or something like that. Correct. Lively, I can't cite a specific article. My understanding from the documents I received is that he was a part of this campaign which contained a lot of content, but to name one specific article, if that's what you're asking, no. So it is, I hate to keep saying interesting, but it just begs the question, doesn't it? Who fed the fire? Was it Leslie Sloan? Was it a publicist of some kind? Was it Stephanie Jones saying, I've got access to this that is going to prove that they did this to you? I feel like it kind of indicates that Blake was stoked a lot by other people. In some ways, I feel like she almost, I think she could be bothered to do the CRD, but she really couldn't be bothered to do the rest of this stuff, I don't think. If she genuinely is not looking at stuff anymore, I think it's because she can't be asked. You know what I mean? Because we've seen at various times that she lacks staying power. And I think that's kind of why she likes to tinker with other people's things. She doesn't want to do the hard thing of seeing something through from start to finish. She wants to play with what's available to her. So I don't think she's got the energy or the motivation to have sustained this for so long. So it does beg the question, what's going on, doesn't it, really? So far, it is clear that Ms. Lively had no specific independent facts of her own to allege the retaliation that she has claimed. We don't have a justice system that is built to indulge every person's feeling that they may have been harmed by someone else. We have a justice system where a person develops specific facts of their own that indicate an action of another's harm to themselves and a causal link between the two. At that point, the person hires lawyers to file a claim based on those facts. Yeah, you have some form of security, don't you? Even if it only illustrates proof in your mind, you have like a grip on something, don't you? But Lively hasn't. The discovery process is only meant to flesh out the particulars and details of the case from the core facts. A fishing expedition is an abuse of the process because even where the process isn't all that burdensome, it becomes undue where the case, as developed, isn't worthy of the burden. And point 6, all the more so when it actually is burdensome, where it risks trampling people's rights and where people are forced to choose between saving thousands of dollars in legal fees or giving up their private financial data to a stranger. Part 2, First Amendment transgressions. This part is quoted verbatim from sections of an earlier motion, Docket 462, as written by the non-party prior to his becoming a non-party or prior to his knowledge of this status. So item 1, the vast majority of Ms. Lively's claims of harm revolve around her allegations that Baldoni, through his agents, propagated truthful yet negative information about Ms. Lively which damaged her reputation, as well that this propagation was allegedly motivated by an intention to unlawfully retaliate against her for her protected activities. In essence, that Mr. Baldoni engaged in speech and expression that violated state and federal statutes against retaliation, namely California's FEHA, and that's Employment and Housing Act, isn't it? And the federal Title 7. 2, more specifically, her claims set out in Lively v. Wayfarer Studios LLC, Docket 84, 224 to 293. Idem must be a legal thing because they mentioned it again. I need to Google more stuff clearly. So as inclusive of, and then in inverted commas here, seeding of content on traditional and social media platforms, the boosting of content, sometimes the very content that TAG and its affiliates had seeded, the suppressing of negative content about Mr. Baldoni, and the amplifying of negative content about Ms. Lively, including through engagement via comments on social media. 3, though Lively and her counsel, she's not successfully proved any of that, has she? So though Lively and her counsel do not detail specifics of what this involves, we can presume that it involves A, writing out prosaic articles and snippets of opinions accompanied by factual information to substantiate them and posting these written words into social media entries. B, having one or more agents of Mr. Baldoni express Mr. Baldoni's positive opinion of these posts by liking the post, engaging the site's algorithm to increase the post's exposure across the network, otherwise known as boosting. C, having one or more agents of Mr. Baldoni express Mr. Baldoni's negative opinion of posts that are critical of Mr. Baldoni by disliking the post or commenting negatively using certain words that are flagged by internal programs, thus engaging the site's algorithm to decrease the post's exposure across the network, otherwise described as suppressing. D, having one or more agents of Mr. Baldoni find negative posts critical of Ms. Lively written by other users and then expressing Mr. Baldoni's positive opinion of these posts by liking the post, engaging the site's algorithm to increase the post's exposure across the network, otherwise known as amplifying. And we know that boosting and amplifying are regular practices of PR people, and we've seen suggestions from Team Baldoni where it's come to positive things about Justin or positive things that are being said on behalf, about Justin or about working with Justin, where Jen Abel or I think it's mostly been Jen Abel or Melissa Nathan have said, let's get somebody else to boost it or some, so that it's or words to that effect. But there's nothing untoward in any of that. And we've got plenty of times where it's been said kind of not to do anything that makes her look worse, that makes Blake look worse. So Ms. Lively has not alleged that any of what she calls social manipulation that allegedly occurred during the summer of 2024 as a result of Mr. Baldoni's hiring of crisis PR managers amounted to defamation. Her claims are that they are wrong solely on the basis that they are pleaded to have been retaliatory, that truthful information damaged her. 5. Yes, it must be acknowledged that a claim of defamation, where statements that Mr. Friedman has made are concerned, has been added to the amended claim of Ms. Lively. However, it is very unlikely she could prevail on such, as Mr. Friedman has qualified privilege, and there is no evidence he disbelieves his client. The closest thing Ms. Lively has pled towards proving knowledge of falsity is a statement Justin made to Melissa Nathan regarding Ms. Lively. I just know her personality, and this is the kind of person that genuinely believes she's right and that all of this is unjust. And I think we can all say in life that we have all come across a person like this who you just cannot reason with, who their point of view has to be what is true. And no matter what you say, no matter what you do, how much information you give to the contrary that can't be disproved, they still don't change their point of view and their perspective. And I'm guessing everybody out there has come up against one of those, either in the personal life or at work. 6. However, even this statement is not dispositive of any such knowledge on Mr. Friedman's part. History is rife with examples of deceptive people who believed they were right despite their lies. Both Presidents Richard Nixon and Bill Clinton spring to mind. During their respective scandals, each genuinely believed they were right and justified in their expressions, even where they were later found to have lied multiple times. In any case, defamation is not adequately claimed. Yeah, it's like people like that. It's like this not fair business comes in, doesn't it? It's not fair that that isn't truth, almost, because I so very much want it to be the truth. It's kind of that, isn't it? People that lie in that way, they need their lies to be true, and there's that element of it's not fair if people don't believe me or if people find opposite to that, even if they have proof. It's not fair that they have proof of that either. So 7, thus the legal question before us is whether Ms. Lively has sufficiently pled or can make a showing that truthful information involving her reputation that was already in the public eye and which are matters of public concern, when expressed by Mr. Baldoni through his agents, constitute legally actionable retaliatory acts. So select factual information and background as relevant to the motion. 8. The allegedly propagated facts Ms. Lively claims harmed her with plaintiff's own sources. A. That Ms. Lively engineers situations in order to take creative control, over productions she's involved in. So in brackets there, several news sources which intimate a creative rift between actress and director, including one from the Hollywood Reporter. They reference competing edits of the film, one sponsored by Lively. Sources state that Ms. Lively and Baldoni locked horns and comma there, over the creative direction of the film, end brackets. So that's a fact that she claims harmed her. But it's like there's no getting around that, is there? B, that Ms. Lively and her associates were not promoting the film alongside its director, and that Blake Lively herself had unfollowed her director on social media accounts. So Deadline article, it ends with us, Justin Baldoni hires crisis PR, mentioned that people on TikTok had noticed Ms. Lively no longer followed her director on Instagram. And in commas there, rumours began to swirl, particularly among fans on TikTok, that there was a big fight between Baldoni and Lively. Fans pointed to myriad examples, read the duo didn't take photos together at the August 6th premiere. Baldoni arrived very early and Lively later. Some observed that Lively doesn't follow Baldoni on social. C, that Ms. Lively, during the promotional events for the movie, discussed upbeat and banal subjects that were off colour to the seriousness of the film's premise. So docket number 84P, blah, blah, links to a Daily Mail article. How Blake Lively keeps getting it wrong. Ryan Reynolds' wife is criticised, which had this to say. Blake finally addressed the domestic violence in her new film that ends with us this week after fans slammed her tone-deaf and shallow promotion of the drama. So point D, that Ms. Lively called this movie about domestic violence her big, beautiful summer movie and asked her audience to wear their florals as though it were a romance comedy to which women should want their boyfriends to take them, and crucially failed to discuss the subject of the film. E, that Ms. Lively used the promo events for the film to concurrently promote her personal hair care line and her drink products, some of which are alcoholic and therefore tone deaf to the subject matter of the film, which was ending domestic V. So, internal reference 85 again links to another Daily Mail article. Meghan McCain slams insensitive and strange Blake Lively over it ends with us controversy. I don't understand why she's famous. dailymail.com. Blake, 36, has been criticised in recent weeks for marketing her personal projects, including her hair care range and her drinks company, seemingly on the back of a film dealing with DV. Ms. Lively also claimed that the absence of her excuse that she was simply following the marketing plan enhanced the damage of claims C and D. 9. Factual demonstration that the allegedly disseminated facts were true or substantially true and publicly available, respectively. A. Blake's reputation for wrestling for creative control is substantially true. Her own public statements prove this. At the 2022 Forbes Power Women Summit, Blake Lively herself had this to say. When I went in the meetings, I would just seem like I'm just there to be the actress and ready to get the gig. I wouldn't reveal that I actually need to have authorship in order to feel fulfilled. So I think that for them, sometimes that might have felt like a rug pull because you're trying to assert yourself into something that we didn't hire you to do. In addition to her public statements, her own evidence proves this happened with the very film issue. I direct the court to docket number 84-2, Lively's contract rider, in which at points 3, 5, 7, 11, 12, 13, 14, 15, 16, and 17, Blake Lively managed to finagle for herself various creative rights she did not earn via ownership of the intellectual property. Rights such as final script approval, choice of hiring of day players and body doubles, the right to dictate other actresses' performances of their characters, that's true, the right to remove content from the film that had already been shot and which she herself was not even present for, the right, and that was clarified by the deposition, wasn't it, where Babcock was asking Blake what she had been present for in terms of filming and where the filming took place. The right to multiple mediators to handle creative differences. And what also that depot extract kind of shows is, again, this sense of this hands-offness, that all of the things she claimed to be doing herself, was she doing herself? As I said before, was she really in that editing room all of that time doing all of the grunt work? Or was she just getting the sound bites of it and just like bits and bobs here and there? Was she physically a bum sat in a seat doing that job? I'm never been sure or convinced of that. Because otherwise, she wouldn't be such in a tizzy about the film footage and all of that, would she? And not having the audio attached to the footage. She'd know exactly what she was going for, because she would have poured over the footage during the editing process. She would have looked at all of the raw footage. The right to multiple mediators to handle creative differences, the right to hire her own additional producer, the right to call her own all-hands meeting. Ms. Lively's own evidence belies her assertion that she didn't take creative control she otherwise should not have gotten. This truthful information was publicly shared by Ms. Lively herself to all cast and crew. As well, she shared it with a third party, Sony, which has no direct affiliation with It Ends With Us Movie LLC. This was not invasion of privacy. Sony was just the distributor, weren't they? The facts that Blake Lively was not did they have an element of funding as well, Sony? I'm not sure about that, but they were the distributor in the main. They shouldn't have been party to the day-to-day running of things. It wasn't their role. B, the facts that Blake Lively was not promoting the film alongside her director and that she had unfollowed her director on social media accounts is substantially true, as well as publicly available information. I mean, the least she should have done was keep following him through to the end of the process, really, wasn't she? If she was being benevolent, if she was taking some things on the chin, the least she could have done was not unfollow him till afterwards. That was an aggressive move, wasn't it? That she knew would be picked up and steer things in her favour. Several media outlets covered promotional events where the cast, including Lively, was not seen with Justin, including the film's New York premiere and an advanced screening at Book Bonanza in Texas. Since these were also public events, it was publicly discernible information. With regard to the fact that Blake had unfollowed her director, this was readily accessible information. And we know it's like the number one thing people go to do, isn't it? At the first sign of, was there a bit of trouble here? The first thing anybody that's being a bit investigative will do is go off and check the socials, isn't it? A simple search on Blake's Instagram account page is all one needs to do to find out if she's following someone. In addition, Ms. Lively's own references to news articles demonstrate that several TikTokers had noticed this fact prior to the alleged digital campaign period. Not to mention that Blake herself admits to this unfollowing in her own complaint. And then in commas here we have that reference. In fact, both Ms. Lively and her husband had unfollowed Mr. Baldoni's social media accounts 10 months prior. So point C and D, the underlying facts of both items C and D and further substantiation for Justin's absence from promotions, the discussion of banal and distracting subject matter, as well as the refusal to discuss the serious nature of the film, in the prior subheading can be found quite readily upon a viewing of Blake's very public promotional discussion panel at Book Bonanza 2024 that was also broadcast on YouTube. So there's various links here to the parts of that business at Book Bonanza, which we're all pretty familiar with now, where there's studiously no real talk of DV of any kind. So that link there, Blake starts off discussing how much she loves the character she plays and how much the book's author loves her, and happily brings up the prospect of Easter eggs in the film, how much she loved the cinnamon rolls she had during filming. Yeah, she kind of references, when I had a look at that, how it asked her like a favourite day of filming or something, and that was, it was the day we had I was going to say it was the day we had the cinnamon rolls, but actually some of the not great stuff happened on that day, so I'm assuming that was to do with filming some of the harder stuff. But yeah, that was the highlight day kind of thing that she brought up. She had during filming, how the production made simple aesthetical mistakes between the book and the film, sort of to do with the tattoo, what the tattoo looked like, and the pronunciation of a character's name. and how they corrected them using special effects. And she ends part one by calling the film a love story. So in part two, which is linked there, Blake variously laughs about how she's not 19 years old, how the actress playing her younger self looks just like her. She gleefully discusses the wonderful casting choices and her fabulous slippers she wears in the film. Then I couldn't find part three, but I did find the entire panel discussion on YouTube there, where additional subjects of Blake's criminal actions of stealing the hard drive from the studio, which contained the not yet authorised cut of the film that Blake edited. I mean, you can imagine that from Justin's perspective, can't you, of that? I mean, how hurtful that would have been, that hard drive getting out there with the unfinished film that has his name on it. He has no real idea of what she has on there, and it's out to the general public. I mean, that must have felt absolutely devastating. And you can't say that's not a vicious thing to do, really, with the best will in the world. So, and her character's difficult decision of which person she loves, her character's Sophie's choice between Lyle and Atlas are discussed very casually. It's a giddy, fun and flippant interview until one remembers this is a serious film about the heartbreak of DV. In point of fact, neither the word domestic nor violence can be found to be discussed throughout the entire panel discussion that day. It's like she managed to not even slip and do it accidentally. Not even to, like if that was the theme and the tone, you're supposed to be doing this as the marketing plan. I mean, I would be terrible because I would accidentally slip. I'd be like the Mark Ruffalo that or the Tom Holland that accidentally gave away the anti-plan. You would think she would have slipped once and accidentally talked about it, but I think part of that is she couldn't have handled talking about that. She's not experienced that kind of hardship, I don't think, so she can't resonate with it, so she can't emote. So she was happy to go along with the marketing plan of let's not talk about DV or SH or anything like that. So Blake Lively did, as part of the marketing of the film, feature her own booze brand on New York morning television. Everyone had access, and it was and is readily available across the country from YouTube. The fact that Blake Lively was actively involved in creating the marketing plan is both public knowledge and a fact which belies her argument. Deadline article from August 11. It ends with us how Blake Lively was a creative tour de force in transforming Colin Hoover novel into a motion picture event, which stated Lively rolled up her sleeves not just for rewrites, but also was involved in editing the movie, all aspects of the PIC's marketing, directing the social media campaign, and jumping into all aspects of it. Deadline is linked there. Since it was widely known that Blake Lively is the person who created the marketing plan for the film, it makes no sense that she should shield herself from the backlash of the elements of her own plan by claiming she was just following orders. In other words, the fact that she was following her own marketing plan means its irrelevance to the allegedly propagated truths is substantially true. Therefore, the fact of Blake marketing the film in a tone-deaf manner being allegedly restated by agents of Baldoni is simply balancing out the discussion on the national stage and would not be deceptive in the least. So legal standard. 10. Supreme Court precedent holds that court judgments based on statutory law are considered state action and therefore must conform themselves to constitutionality in order to be valid. New York Times v. Sullivan. What a state may not constitutionally bring about by means of a criminal statute is likewise beyond the reach of its civil law of libel. Oh, I'm burping and I haven't even had any food. It must be just having the water. Ms. Lively has brought suit under Californian and federal civil statutes against retaliation, specifically California Government Code section blah, blah, blah. And that's part of the Federal Employment Housing Act and 42 USC, also known as Title 7 of the Civil Rights Act of 64. Therefore, if Ms. Lively desires to have this court apply these statutes to punish or otherwise curtail truthful yet negative speech concerning her reputation, it is her burden to prove that such application in her case is not violative of the First Amendment, or in the alternative that her evidence exceeds the level of scrutiny that can form a justification to restrict the constitutional right at issue. Case law quoted there, which states that when a law restricts speech based on its content, It is subject to strict scrutiny, meaning the government must demonstrate that the restriction is narrowly tailored to serve a compelling state interest. Point 13. What we must ask ourselves is what level of scrutiny is truthful speech protected by, and then ask ourselves if the plaintiff in this case can reasonably expect to surpass that level with the evidence she has so far. 14. Multiple landmark Supreme Court cases have set a very high bar for this. In Bartnicki versus Whopper, the court upheld free and truthful speech on a matter of public concern, even where criminal statutes against wiretapping were invoked. B. In Hustler Magazine versus Falwell, the US Supreme Court held that even malicious opinion widely publicized was not actionable under tort law, that the intent to cause emotional harm and other harm was not justification enough to curtail free speech rights. I mean, the judge himself in this case has said that when it came to Baldoni's case that was dismissed, that many of the things that Blake did was hard bargaining, could be called hard bargaining, you know. C. Smith versus Daily Mail Publishing. State action to punish the publication of truthful information seldom can satisfy constitutional standards, and if there exists truthful information about a matter of public significance, then state officials may not constitutionally punish publication of the information absent a need of the highest order. Butterworth versus Smith. Our decisions establish that absent exceptional circumstances, reputational interests alone cannot justify the proscription of truthful speech. Reed versus Town of Gilbert. Innocent motives do not eliminate the danger of censorship presented by a facially content-based statute, as future government officials may one day wield such statutes to suppress disfavored speech. That is why the First Amendment expressly targets the operation of the laws, i.e. the abridgment of speech, rather than merely the motives of those who enacted them. 15. Additional rulings for the court's consideration. While the United States Supreme Court has not yet weighed in, social media engagement such as liking a post has been categorized by lower courts as protected free speech, because it's giving your opinion, isn't it? The case of Bland v. Roberts remains unchallenged. It's like when I do likes as well, especially like on YouTube, on people's comments, I think of it in terms of paying for what they've produced as well. You know, when I'm, even if I don't necessarily like the video, I tend to think, well, it's informed my opinion going forward, positively or negatively, or, you know, it's been further information whether I choose to take that on board or not. So I think of my like as thank you for that, whether I agree with you or not. It's helped my mind form a different perspective or something like that, I guess, as well. Section B, arguments regarding motion to quash certain subpoenas in their entirety and modify the subpoenas. I do believe that these subpoenas are overly broad, unduly burdensome, oppressive, and clearly and convincingly brought for an improper purpose. However, in addition to that argument, they fail particular legal tests which are persuasive in this circuit. The Dendrite test from New Jersey, and there's Cohen versus Google in New York. Both cases endorsed and used legal tests which require at minimum a showing of a prima facie case before initiating disclosures that jeopardize the non-party's right to anonymous speech. This, I mean, the length of time this has taken and the research and all of it, agree with it or not, it's rather brilliant, isn't it? I don't see how the judge can in all good conscience just dismiss it out of hand as coming from a non-party. It's got very real arguments within it. Regarding Cohen, the New York Law School Review had this to say: the Cohen Court's meritorious cause of action standard requires a plaintiff to make a prima facie showing of a cause of action before it will issue a court order for a pre-action disclosure. And all of these content creators were saying, please tell this woman she has to have a cause of action. Why does she need our information? She's not coming before your court and stating why she needs this information. 2. Ms. Lively's claim for retaliation has clearly failed to do so. Therefore, I move to quash the Google X subpoenas in their entirety and further to modify all of the subpoenas to the effect that communications with people anonymous to the individual subpoenaed are not discoverable. Section C, arguments regarding sanctions for abuse of process right. So, one, there are certain abuses of process that affected me and all of us non-parties collectively, but they are all part and parcel of a larger scheme of such abuses, and therefore the whole ball of wax becomes relevant. It is getting hard to distinguish one element from the other to this case. They're so entangled. The first abuse of process on the part of the plaintiff in this case that we are aware of is a Van Zandt subpoena that you're all bloody ignoring on, the Blake's side and the judges are ignoring. Blake Lively has admitted in her deposition that she personally has no facts to support her claim of retaliation as evidenced above. Therefore, she had no such facts when she commenced this litigation, which of course includes the preparation phase. Therefore, when Ms. Lively allowed her lawyers to file a dummy lawsuit against fictitious and unknown individuals, ostensibly in a contract dispute of all things, she had absolutely no justification for doing so. For the sake of this mission, her legal team at Manat, Phelps and Phillips offered up the casualty in the form of attorney Miss Samantha Catsey. Catsey broke every rule of professional conduct in the book when she filed this fake atrocity of a lawsuit in New York State Court. In so doing, she intentionally misrepresented to the court that she intended to follow through on a legitimate lawsuit when she had no such intention. She and her handlers at MP&P used the dummy suit as a means to circumvent the defendant's right to confront their accuser and rights to due process, to deprive them of fair notice that their private information was subject to subpoena and disallow their opportunity to object. When the fake action had served its purpose, they secretly moved to close it without any judicial oversight whatsoever. 3. What did Ms. Lively's attorneys discover from this? Well, they uncovered evidence of normal PR tactics that everyone in Hollywood, including the plaintiff, engages in lawfully every day. Even Ms. Lively's own mother was once an agent who spun PR and marketed actors and actresses for a living. But to a paranoid and troubled young woman, these tactics were going to be seen as threatening to her. Her lawyers again used that to feed this delusion and their client's desire for vengeance. When their client became inflamed by this provocation, she paid out more money to act on it. This is the pattern of improper motive. 4. It is clear that although Ms. Lively is a troubled, vengeful person with delusions of persecution, she is not unintelligent. Her lawyers know this. They know that it isn't enough to simply state that there are parties taking action against their client. She would not continue to believe such things to her detriment unless there were actions by others that she could see with her own eyes and interpret as threatening. Ergo, Miss Hudson and Mr. Gottlieb needed certain pressure points or metaphorical lightning rods to take the brunt of their claims and put on the best show for their mark. Brian Friedman became the main event. They targeted Brian with volleys of legal maneuvers in expectation that he would defend his client and himself in the most public and impactful ways, which he did. And that show proved to Ms. Lively once again that she needed her lawyers and lawyers need money and the cycle restarts. It's pretty brilliant, isn't it? 5. That is where us non-parties come into the equation. They could only get so much play out of Brian Friedman, and the biggest blow to their scheme came when Justin's defensive lawsuit was tossed out. The first lightning rod had burnt out. They had to pivot. And that's the thing, they do keep pivoting. We said it ages ago, didn't we? And that narcissists do pivot if something's not working and they're not getting the energy required. This case has kept flipping from being about SH. The next thing, the SH disappeared and it was about defamation and retaliation. And when that wasn't working, it flipped back, or somebody else had to be involved, or whatever it was. 6, it was too much of a stretch to come after us directly. That would risk breaking the illusion in Lively's mind. So they set up an intermediate lightning rod, Judge Lewis J. Lyman. If they could dupe enough of the non-parties into believing Your Honour was biased and have them speak out openly of such speculation and ridiculousness, then they could show Ms. Lively a new target for her paranoia and vengeance, the community of online content creators who are skeptical of Ms. Lively. Look, Blake, Brian Friedman has come at you with a new band of paid accomplices, and they're even going after the judge for siding with you. We've got to do something. Give us more money so we can take them down. Ms. Lively took the bait and authorised the expense for a huge attack on over 100 non-parties and their First Amendment rights. Isabella Ferrer and James Vituska are the next rods to be erected, and that is where we stand today. 8 to be absolutely clear that so there is no doubt, I'm not stating that the subpoena process itself is abusive. It is an integral and necessary part of the justice system, but there are limits. The subpoena process is not meant to allow a plaintiff, with no basis in fact for her claim, to exact revenge on the people she believes are wronging her merely because they are speaking their mind on the validity of this case. It is especially not meant to enable unscrupulous legal agents to swindle their rich and motivated client into pouring huge amounts of their money into a meritless claim. I seek monetary sanctions on behalf of myself and the group collectively. I make a recommendation to the court that each member of our collective who was forced to and did respond to these frivolous subpoenas be awarded $500 in punitives for the abuse, and if it please the court that these sanctions be ordered not to come from the legal fees they are charging Ms. Lively. I also seek that any other motions that others of my group have written be appropriately seen to and adjudicated, and I seek to enable the court, if it be needed, to impose whatever further sanctions the court deems appropriate for these misdeeds. $500 seems like an understatement. That's incredibly generous, I would think. I'd have been thinking it was more like 5,000 a piece, which is nothing to Blake Lively anyway, is it? Geez. Some of the blouses probably cost more than $5,000. She could sell a few bits on eBay, couldn't she, to balance it? Section D, arguments regarding contempt of court motion. How much bloody long is this thing? Contrary to popular belief, contempt of court encompasses more misdeeds than a refusal to follow court orders or decisions, at least in the federal realm. It also includes misbehaviour of court officers in their official transactions. Such prohibition can be found at 18 U.S.C. Section 401(2). Two such categories of misbehaviour are listed in the New York Rules of Professional Conduct and proscribing acts of misrepresentation as well as acts prejudicial to the administration of justice. It is my considered belief that lawyers for the plaintiff in this case manufactured a falsified appearance of impropriety on the part of the court, namely a bias in favour of their client. They did so with utter indifference to the risk of broadly undermining judicial authority and inciting disrespect against the justice system. They did this with the intent of using the misled public outcry against this appearance as a signal to their client to reinforce her delusions and steel her resolve to throw more money at the legal case. Look, Ms. Lively, now Baldoni and his allies are even going after the judge just because he likes you. Their depravity knows no bounds. Let us write up another motion for sanctions and don't worry about the cost. We'll get Baldoni to pay for it when you win. 2. In Exhibit C, I summarise very key insight into the timeline of the events that culminated in this widespread false belief of judicial bias. It is not simply a case of sour grapes from a ruling. It was a calculated framing of the factors by the plaintiff's counsel with a few lies thrown in. It started with your ruling on June 9th, dismissing Justin Baldoni's countersuit for failure to state a claim. The Edgeworth protective order had recently gone through without issue, so this wasn't a case of a mob primed to take bad news in the worst way. What happened to make it different this time? Simple. Blake Lively and her attorneys made deceptive public statements that led people to a seriously erroneous conclusion. I think the Edgeworth protective order, from what I remember, was the thing to do with the information extracted. Wasn't that Stephanie Jones side of things? Wasn't Edgeworth the company that had to forensically extract the information from her side of things? I think that is correct. I'm sure you possibly know better than me out there. 3. In your honour's ruling found in docket number 296, page 131, the court could not have been more explicit that California Civil Code 47.1 was not the basis for the ruling. Yeah, because he disregarded the amicus briefs. He hadn't read them when he came to that ruling, had he? And on top of that, all of the many recent amicus brief requests were immaterial and did not form part of the court's decision process, as the court has not considered any of them. However, the plaintiff and her lawyers took to social media and the press respectively, and after a victory lap, they both misrepresented the court's ruling. The plaintiff herself had this to say: last week I stood proudly alongside 19 organisations united in defending women's rights to speak up for their safety. And further, while the suit against me was defeated, so many don't have the resources to fight back. And finally, I'm more resolved than ever to continue to stand for every woman's right to have a voice and protecting themselves, including their safety, their integrity, their dignity, and their story. I mean, Blake at that point really did think this was all over by the shouting, didn't she? She thought she had it won. Ms. Lively intentionally gave everyone the impression that the 19 organisations who filed amicus briefs in support of 47.1 stood by her side and helped to defeat the retaliatory lawsuit, implying that Your Honour had been swayed by these organisations' emotional pleas to overlook the law and rule based on societal pressures. Of course, Ms. Lively is not a lawyer, so it carries less weight, but her lawyers failed to correct their client's official story. They were too busy doubling down on the falsities. They released a simultaneous statement. Today's opinion is a total victory and a complete vindication for Blake Lively. As we have said from day one, this $400 million lawsuit was a sham, and the court saw right through it. And here's the most important part. Even though Your Honour had just ruled that attorney's fees, and specifically the treble damages invoked by 47.1, were denied, these lawyers couldn't help bringing 47.1 back into the frame immediately. We look forward to the next round, which is seeking attorney's fees, treble damages, and punitive damages against Baldoni, Sarowitz, Nathan, and the other Wayfarer parties who perpetrated this abusive litigation. As Your Honour knows, the only legal mechanism linked to this case which could accomplish a treble damages finding is through 47.1. which requires a whole new lawsuit on its own, doesn't it? As Wayfarer have been trying to point out to Wesley Sloan. I nearly said again, Wesley Sloan. Oh no, I'm never going to be able to say Leslie Sloan again. I don't think it's always going to be Wesley Sloan and Blake Snipes. Yeah, if she wants damages, she really needs it to raise a brand new lawsuit. Collectively, Ms. Lively and her attorneys gave the impression that judicial bias was at work in her favour. For her part, Ms. Lively wanted desperately to believe that someone was on her side without needing to be paid. Yeah, that's what's a bit sad, isn't it, really? That's what we've said before. You can see that sense of camaraderie among the various Wayfarer elements, and they've not turned on each other. Everybody on Blake's side of things is a paid person. Where are all her friends? Where are all the cast that, Leslie Sloan said all of the cast, she could get all of the cast to stand up and say that Justin had been abusive. So where are all the cast supporting Blake Lively? It is sad. It is a sad thing. Whereas her attorneys had the sinister motive to provoke the backlash that secured their continued access to the Lively Reynolds cash machine. 9. It was only after these false and misrepresentative statements were made that the court became subject of scepticism and accusations of impropriety by well-meaning yet misinformed people on the side of truth. The plaintiff's attorneys either knew or ought to have known that they were producing the falsified appearance of impropriety, impugning the justice system for their own ends. They should therefore be held in contempt of court. So, wow, yeah. And the thing is, why it should be covered in full, even though I'd rather not take the time to do it, is that this is like just a regular person basically saying, highlighting the scope of the effect this has had on people, and even the likes of you and me who weren't subpoenaed but are heavily invested in the outcome of this at this point, and the way we've been manipulated and the rest of it. And like everybody, whether you have been a victim of SA or SH or DV or whatever it is, all of us have been victimized in some way or other. I think it would be very hard to go through life without having been the victim of somebody or something at some point that you couldn't win, that you had to just take on the chin or whatever it is. So that's why it does appeal to all of us and why it is important. So I'm going to wrap it up at this because it's already gone pretty long, but I'm just going to have a quick look because some of the exhibits referenced in that weren't available at the time before I started filming, but Exhibit C was evidence of impugning the court. So Your Honour made the following rule, or the 6 pages of it. Don't want to keep you all watching. Let's just blow it up a bit. So the court denies the motions without prejudice. That's about the fees. The court has not ruled on whether Lively's statements were privileged under 47.1. Denied without prejudice to renewal by formal motion. Your Honour then clarified that amicus briefs that were never admitted to the docket had no bearing on this decision. The court has not considered any of the briefs in resolving the motion to dismiss. Hours later, these statements were released. Blake Lively reacted to Justin Baldoni's lawsuit against her being dismissed, while the suit against me was defeated, so many don't have the resources to fight back. On her Instagram story, she referenced the 19 organisations that wrote amicus briefs in support of her. Last week I said blah, blah, blah. La, la, la. Blake's lawyers backed her up in this falsity. Claims total victory. Judge dismisses abusive $400 million lawsuit. They really do bang on about money, this side of things. They really took offence at this 400 million figure, as it's almost like saying, you little people, how dare you talk in terms of 400 million? And at the same time, how many times billionaire Steve Sarowitz is brought into legal filings? They're billionaire Steve Sarowitz, this, and it's like I said, it's like it became his first name, billionaire. I think that's what you feel when you read a lot of their documents. It's like pure outrage at how such a little person like Justin Baldoni and his friends dare take them on, dare have a voice. I think you get a sense of that, and I think that's what a lot of us pick up on. It's that feeling of one person considering themselves more valuable, more worthwhile than another person. So that's that. Yeah, casually tossing out the 400 million lawsuit filed by what they use that 400 million figure to make it sound ridiculous. How can anybody consider taking out a $400 million lawsuit? And then 2 days later, the speculation had begun. How many conflicts of interest did Judge Lyman forget to disclose? And everybody was talking about that basically, weren't they, on various channels. Blake Lively's tie to Judge's brother revealed after her shocking win in Baldoni case. And of course, we all know how that influenced Perez Hilton's recent hot takes on the subject. And Blake's lawyers never walked back their statements or corrected the record in any way. So anyway, I'm just going to stop sharing. So I hope that was of interest to you. I think the contributions of J. Alexander Townsend are very valuable. I'd love to know who it is. If they want to contact me privately, they can. It would just satisfy my curiosity because they're doing such a good job of it, I think. And it's thought-provoking and it crystallizes it all very well, I think, and presents it back in a way that you can absorb, because sometimes with the filings, it's very hard to absorb what's going on, and the nature of Lively's side bombarding the docket in the way they do means a lot can and has probably slipped under the net in a way, and we forget big chunks of what was really relevant going back in time. You know what I mean? It's very hard for me to keep track of it. I don't seem to absorb the information in the same way that certain other people do. It's the feelings that get to me. Anyway, I do hope you enjoyed it, and you can drop me a comment if you want to, and please do hit that like and subscribe and share if you can. And let me know if you would like it presented in a different way, or if the longer recordings are of so much of interest to you. But thank you for watching and sticking through to the end, and I will see you all again soon.